Okay, good afternoon. My name is Marshall Kaminer. I'm the chairman of the New York City Loft Board. I'd like to welcome you to our July 17, 2014 public meeting. I'd like to give you a brief background. I've been with the buildings department about 11 and a half years, and I've served in the capacity as Borough Commissioner in the Bronx, Borough Commissioner in Staten Island, and I'm currently the Executive Engineer and Technical Affairs and Code Development. All right, the minutes. So we're going to have a vote on the April 24, 2014 minutes. Are there any other corrections or comments to these minutes?
Yeah, I have a couple of questions. With regard to the scanning of the files, what kind of funding is being obtained for that? Is it, or where does it come from?
Well, I imagine that it would either come from the Loft Board's budget or DOB's budget. I am not aware of any other funding stream for that type of.
Okay, there's no Office of Technological Facilitation, or do it, doesn't do this?
No, do it, doesn't do it.
Okay. All right, because it certainly seems that would be a great thing. Okay. My other question was regard to the question of the law department. I recall at the last meeting, even though it was quite a while ago, I had inquired whether they had put their opinion in writing on that. And I thought, as I recall, you were going to look into that.
Yes, there was nothing in writing.
All right. Okay. Thank you.
Any other comments or questions? Is there someone who could move to accept these minutes?
Sure.
Okay, thank you. Is there a second? Okay, thank you, Mr. Delaney for accepting them, and thank you, Leanne Shelby for seconding. Ms. Rivera, would you please poll the board members?
Mr. Burris?
Yes.
Ms. Kurzman?
Yes.
Chairperson?
He's going to abstain.
Mr. Delaney?
Yes.
Ms. Bolton Rivera? Mr. Fagan?
Is absent?
Mr. Shachter?
Yes.
Ms. Johnson?
Yes.
Six in favor, one absent, one abstain.
Thank you.
Annie Alexander, our executive director, will now give her report.
Thank you. Good afternoon, everybody. I'm going to wait a minute while Mr. Foggin gets himself settled.
Apologies.
That's all right. It's public transportation.
Thank you.
The first thing I'd like to do before I start with all of the statistics is to ask the board, I had asked them in an email, I've sent the statistics to the board in preparation for this meeting, and I asked the board how they wanted me to go about presenting these statistics. Generally speaking, I've been sort of by rote going, just reading off numbers. There is an alternative for that, and that is to just sort of give the overall numbers and post the statistics online along with, on our website, along with the minutes. And I posed this to the board, and I want to know how everybody felt about that. First of all, I'd like to know the way all of the statistics were presented to you. Was that something that was easy for you to understand, and was that satisfactory for all of you?
It's comprehensible, but my question is, since we don't make any determinations based on those statistics, do we need to have them every time, or?
No, we do them now every 3 months. And it's just informational so that you can see how the buildings are progressing through the legalization process. If you wanted to do it every 6 months, that would be fine too. You let me know. But, so that was all comprehensible. What do you think about not having these read out necessarily at the meeting, but just having them accessible to everybody who wants to see them? Yes, Ms. Hollenberg?
I think I had requested at least once a year if we could get a comparison with the year before.
Okay. That's very easily done. Thank you.
So I think 3 months to me strikes me as about the right period in which to get a sense of where we are. I think it's particularly interesting to see how many new cases have come in that time. So I would ask, I don't think they need to be read out at the meetings if they're publicly available. In fact, I have to confess that perhaps my colleagues are brighter than I am, but it was hard to just hear the litany of numbers at the beginning of the meeting and to be able to make heads or tails of it. Seeing it in advance and being prepared to come with questions, I think is more effective.
I agree with you. From my point of view, it's very hard to just sit there and read the numbers.
Right.
I often get them all mixed up. But that's beside the point. But I understand that. So what I will do, instead of going through all of these, is that I will just announce that we have 331 buildings in our jurisdiction. Of note is the fact that we have 247 buildings that were registered under 281.1 and 281.4. That was what we call the old law. Under the expanded law, we have 84 buildings.
I think those are the three statistics that are most interesting to me, particularly the laggards of 281.1 and 281.4. I would like to know what, I don't think there's any way we're going to find out why these buildings are not coming into compliance. That's, I remember when we celebrated, and we were down to 300. So now we're down to, what is it,
247.
247. I mean, this was when Mark was here, so that's...
It's been 5 years. It's about 5 years ago that we hit the 300 mark, and we've only really gone down 22 buildings.
Well, we're speculating or wondering at this corner, what happens? We can't go after those 247 people, right? You're basically stuck waiting for them to take an action, somebody, either the owner or the tenant.
Well, no, what we do is we are following, and that's what our milestones are about. We follow them, and we are working diligently with the owners and the tenants of those buildings to get them finished. Excuse me. If you look at the milestone breakdown, it's the green sheet that will be posted on our website. The number of buildings, for example, that have Cs of O's are 34. That's pretty good. We have 94 that are in the permit stage, or no, in TCO, and 93 permit. There are very few buildings that are in the narrative statement process, and most of the ones that we have here listed as in the narrative statement process are those buildings that over the years have come back into the narrative statement process because they've amended their applications. So you can see that these buildings, while they are slow, are moving forward. And as a matter of fact, another interesting statistic, which I gave you, was that we have 2,604 total units. And as of now, we have more units in the 84 or so, whatever I said, 281.5 buildings than we do in the 281.1 buildings. We have 1,482 in the new buildings and 1,282 in the old buildings. So another statistic that I wanted to give you is that we we are in our registration period, we're just ending it. We have 232 buildings that have registered. We have gotten $897,810 in registration fees. Starting in September, when the application, the renewal of registration time period has ended, we will start making telephone calls to those people, those owners that have not registered. And then when that period of time is over, we give them a month or so to register. And then we will begin the process of enforcement on registrations. I wanted to tell you about Article 78s that are pending. We have 5 Article 78s pending right now. One is in matter of Pels, and this is where the owner at, I think it's 99 Commercial Street, is appealing the Loft Board's determination regarding the incorporation of a hallway and a bathroom in the first floor IMD space of Marsha Pels. The second one is Goins, in the matter of Goins, and this is where the Loft Board determined that his application to reopen a removal application from the year 2000 was time barred, and they are appealing that. In the matter of Grant is an appeal of the Loft Board determination where we determined that there were 2 units on the floor and not just one. He wanted to have it be combined. And then we have, in the matter of Crosby Street, and this you might have seen in the newspaper this week, this is where the tenants who are living in 2 units where the rights had been bought out previously are claiming that they want the 7C rights. The judge and the Loft Board all held that these 2 units were subject to a sale of rights and that they were not the protected occupants. And then the final one is Thames Street, and here the tenants are claiming that the Loft Board erred when it went into executive session to discuss the case. So those are Article 78s, and as the decisions come in, I will let you know. As some of you know, we moved to the 4th floor. I want to thank the Manhattan Borough Commissioner, Marty Redholz, who was the person who created this plan to move some of his people from the 4th floor into the 3rd floor, where he currently has most of his staff, and move us up into that space. I want to thank Kara Auger and Mark Sanabria, who worked so hard to get us there, to get the construction done on time, and to move us up there and give us the best that they had to offer in terms of space and facilities. However, there's still a lot of work that we have to do because we are still archiving files and we are unpacking and bringing files upstairs. For those of you who do not know, the tenants proposed some changes to the loft law, and that was brought up to Albany. It passed through the Assembly, but it did not make it to the floor of the Senate. This, among other things, the most important thing that I think they were seeking was to lift the statute of limitations, and so the statute of limitations will stand, and I'm certain that they will bring it again next year. Mr. Schachter asked me yesterday in an email that he sent to all of you, what happens when the Loft Board rejects a proposed order, an order that is proposed by the staff? Remember what the process is we get the cases back from Oath, the lawyers for the Loft Board review it, we come up with a proposed order which we give to the board for consideration and vote. Generally speaking, what happens is the board tables the case after a discussion, or they will have a discussion and instruct the board staff to go back and either do some research or rewrite something in a different way or correct something. In one case, in my recollection, we had a removal case, and the board said, we can't vote to remove this case, staff. This is a building that is now completely commercial, but we note that there were no buyouts of any of the units, and so this was not done correctly, and so we will not permit it to be taken out of the Loft Board's jurisdiction. Staff, find a way to deal with this, and we did. Ultimately, the owner of that building found the former tenants in the building, bought their rights, and in some cases had already bought their rights, and we didn't know about it, and they hadn't given us the information. And so once they bought the rights, they gave us all of the sales of rights agreements, they gave us their declarations of intent, and then we left the case, we gave the case back to the board for a vote, and they removed the building from our jurisdiction. In this case, the board voted to reject, in essence, they were rejecting our proposed order. And based on what the board said during the discussion, the Loft Board staff went back and rewrote the proposed order. And now, because it has now become a substantive case where we have to, do more than just accept a settlement, it became a master calendar case. And that's what we've done. What happened this time is extremely unusual. I think it happened in my tenure. I don't know about the rest of the time that the Loft Board has been, excuse me, doing that. But that's basically what we do. So are there any other questions about that? No? Mr. Delaney?
Not on that, but I'd like to, we kind of left the statistics, I didn't realize.
Oh, please. No, we didn't leave, we
Just by way of your 5 Article 78, can you give me the name of that second one again?
Sure. Second one is in the matter of goins, G-O-I-N-S. Okay.
With regard to the idea of posting the statistics on the website, I think that's a great idea. What is it that you would be posting?
Well, I was considering posting the milestone.
Mm-hmm.
I was also going to post the applications, that very long and sort of dreary report that we give on the number of where the cases are currently.
Right, just applications,
Right. Mm-hmm.
application statistics.
Right. And if there's something else that you would like me to post as well,
Would you post the statistics report as well?
if you'd like, certainly.
Yeah, I would think the more people, I mean, none of this is secret. Really.
No, and it's all foilable that way.
It's all foilable. And the one suggestion I would make,
Yes.
I realize this would be some work initially, but on the list, the list of buildings, the long one,
Mm-hmm.
if at some point you could go and in addition to, the bin number and the low house number and all that, if you could put in an additional column that gave the number of units that were registered when the building was initially registered, I think that would be very helpful. Obviously, it would be extremely laborious to keep updating that when somebody buys someone out or something, but just as we, as the question comes up, what are these statistics
Well,
valid for?
maybe it would be just easier to put in, I understand what you're saying. We have in our database, for each building, a list of the units
Right.
and their status, whether it's a regular unit, it's been bought out and residential bought out or abandoned, so we do have that information, certainly.
Right, but my interest is not so much, particularly in some of these Brooklyn buildings where you've got 40 units, and if 2 get bought out and it drops to 38, that's not, I think, particularly significant. But as we look to see what buildings complete legalization and what buildings don't, having a sense of the size of the building might be kind of helpful.
I'll certainly do that.
That would be my one request on that.
Any other statistics or questions that you have? Anything that you think might be helpful?
I do have one other question.
Sure, Mr.
We're now at 349 pending cases. Actually, I have two questions. But only in the 3 months since we last met, only 2 new cases made it to the agenda. So could you give us some sense as to why that is and how we're going to
Well,
cut through
in
this
the
backlog?
past, what we did was we did, while we have been working on new cases, we did not finish them for this meeting because we've been moving.
Ah, okay.
That's why. And that's the sole reason. It's not that anything other than that.
Okay. And the schedule is really follow-up. There's going to be no August meeting. So
No August
the
meeting, and then,
is-
right.
Okay. And the other question, the last question I have is, if 232 buildings are registered, and we have 331, that means 100 haven't so far,
Something like that.
which seems like a pretty hefty,
Exactly. We will be following up on that
yeah.
in August.
Okay, all right.
Any more?
Anything else? Thank you very much.
Okay, cases. We're now turning to the summary cases. There are 8 summary cases. These cases are voted on as a group. They are, number 1, Daniel Mechanic, Gintis Janisonis, Jonas Smith, and Lex Graves at 70 Flushing Avenue. That's number TR 0883. Number 2, John Thomas Ada and Alessia Erin Locke at 269-271 Messerol Street, Brooklyn, TR 0940. Number 3, Michael and Lynn Hassan, 70 Flushing Avenue, Brooklyn, number TR 0955. Number 4, Edward John, 2413 3rd Avenue in the Bronx, TR 1029. Number 5, Paul D'Agostino, 250 Moore Street in Brooklyn, TR 1034. Number 6, Robert Rush, 547 Broadway, TR 1087. Number 7, Nathaniel Ward, 250 Moore Street, Brooklyn, TR 1113. And finally, number 8, Jonathan Ellison, 250 Moore Street in Brooklyn, TR 1123. Does anyone have any questions or comments about these cases? Is there a motion to accept the summary cases? Thank you, Ms. Shelton. Ms. Shelton accepts. Is there a second to accept? All right. Thank you, Mr. Schachter, for seconding. We now come to the master cases.
No.
Oh, I'm sorry.
That's okay.
I'm sorry. Ms. Rivera, would you please poll the board members?
Mr. Barrett,
Yes.
Ms. Grossman, Chairperson,
Yes.
Mr. Delaney,
Yes.
Ms. Buden Rivera, Mr. Baggins,
Abstain.
and Ms. Schachter.
Yes.
Ms. Shelton?
Yes.
7 in favor, 1 abstain.
Okay. The first master case is case 9. Sealand Realty Corporation, 17 West 20th Street, number LB0185. Ms. Cruz, would you please present the abandonment case?
Good afternoon. On May 16, 2012, the owner of the building at 17 West 20th Street filed an application seeking a finding of abandonment based on the death of the occupant of the Unit 2W. As proof of the tenant's staff, the owner presented a permit from the New York City Department of Health and Mental Hygiene to transport the tenant's remains to Alabama, the tenant's obituary, and a program for his funeral service. The record also shows that no one asserted a succession claim after the tenant's death. The record contains an affidavit from the tenant's brother in which he surrendered possession of the unit and confirmed that no other person has a right or a claim to the unit or is in possession of the unit. The abandonment application is timely because the owner filed the application within a year from the tenant's death as required. In her report, the administrative law judge recommended that the board grant the application, and based on this record, the staff recommends that the board accept the recommendation.
Does anyone have any questions or comments about this case?
I have a question, but it's not about the proposed board. Are there other units in the building that are registered or pending?
Pending as in other IND units in the building, yes.
What happens to this unit?
So it's still subject to legalization, at least right now, because the owner has not indicated that it intends to convert back to commercial use. It's just not subject to rent regulation and gets a CLO within a certain time period.
Is there a motion to accept this case? Thank you, Mr. Barowitz. Is there a second? Thank you, Mr. Fogan. Ms. Rivera, would you please poll the board members?
Mr. Barrett,
Yes.
Ms. Chrisman,
Yes.
Chairperson,
I have to recuse myself.
Mr. Delaney,
Yes.
Ms. Bowden Rivera, Mr. Foggins,
Yes.
Mr. Schechter,
Yes.
Ms. Shelton.
Yes.
Seven in favor and one recused.
The second master case is case 10 at 55-65 South 11th Street, Tenants, and it's located at 55-65 South 11th Street, and the number is TR0829. Ms. Cruz, would you please present the coverage case?
On November 9, 2010, various tenants of 55 South 11th Street and 65 South 11th Street filed an application seeking Article 7C coverage pursuant to 281.5 of the multiple dwelling law. On August 17th of 2012, the owner and the tenants executed a stipulation in which the tenants withdrew their coverage claims with prejudice, and the owner agreed to allow the tenants to remain in their units while the owner completed the legalization work necessary to obtain the residential certificate of occupancy for the building. The Department of Buildings has issued a permit for the legalization work, but a residential certificate of occupancy has not been issued. At the last meeting, the board rejected the staff's proposed order to accept the tenant's withdrawal. Accordingly, the staff prepared this proposed order, rejecting the stipulation based on the illegality presented by the terms of the stipulation. Section 301 of the MDL prohibits residential occupancy of a multiple dwelling in whole or in part until the issuance of a residential certificate of occupancy. This restriction also applies to buildings like the one at issue here, which seek to convert to a multiple dwelling. Therefore, any residential occupancy of the building prior to the issuance of a certificate of occupancy is illegal. Article 7C provides an exception to Section 301 of the MDL. Section 283 of Article 7C explicitly permits residential occupancy during the legalization process for INDs. However, here the tenants have agreed to withdraw with prejudice their Article 7C claims, but will continue to occupy their units while the owner does the legalization work. The tenants' withdrawal of their Article 7C claims renders their current residential occupancy illegal. The proposed order before you today rejects the stipulation and reflects the board's consensus that the stipulation does not promote public safety and safeguard the public interest, and the board cannot disregard ongoing illegal residential occupancy.
Does anyone have any questions or comments about this case? Yes, Mr. Blaine.
This building has an IMD number. Is that
It
correct?
may have had an IMD number, but I think that IMD number was revoked at some point prior, and I'm not sure why we put it here, but. It's not IMD number.
So it had an IMD number that was revoked?
This is not the first time tenants have sought coverage under this, under Article 17.
That might be a mistake. We'll have to look and see what that IC number is for.
Because it was, I think it was also, yeah, it was listed as having an IMD number when
Before.
it came up in April as well.
Yeah, I have no recollection, I have no idea what that's.
Okay.
We'll certainly make sure that see what's going on there.
You're relatively certain that there isn't an existing group of units in the building that are in fact an IMD?
Yes.
Okay. All right.
Are there any other questions? Yes.
Yes, and this may have been covered in the last meeting, and I just have forgotten over the passage of time, but should, my sense was, perhaps I'm still too much of a happy blow, discussions about coordination between law board and department building staff and how that has sort of improved the program. But it's, how did DOB approve the alteration applications without coordination with the law board staff?
That's a very good question, Mr. Schachter. And the answer is that it's in a zone where residential occupancy is permitted
As of right.
as of right. So they don't need IMD status in order to, unlike some buildings that are in completely manufacturing zones and cannot be legalized for residential use without the IMD imprimatur on it. This building and many other buildings don't need IMD status in order to legalize the building's residential.
So it's, okay, I'm sorry, I have to, because I'm just reading to convert existing manufacturing offices and buildings to residential use. So they can do that as of right
They
without...
can do that as of right. And another part of this concept of the application is pending. The plan examiners have asked us, and part of our training for the plan examiners was to tell them that if they see application pending on their the building's information system, they are to treat that building the way they would treat any other non-loft board building. So if you get an application to do legalization work to make a residential building in an M zone, you reject it. But if it's, because it's not an IMB, but if you get an application to do alteration work in a residential zone, there's no problem. You just do it as, you go forward the way you would always go forward.
We don't know what kind of building this is. Do you know how many stories this building is? Or anything like that? Do you know whether... I frankly, I can't understand how... I mean, this building is sitting in an R zone. And what's been its use over the years? It's been sitting in an R zone, and now the landlord says, what do he want? Wants to make Class A apartments out of it?
Yes.
That's what he wants to do. So he says to the tenants, all right, stay here, I'll make Class A apartments, and then what? And then we'll see.
No, I think that in the stipulation, he says, I'm going to make Class A apartments, and I'm going to make them rent stabilized.
Treat them as.
Treat
if
them
they
as
were-
rent stabilized, and I'm going,
And then I'm going to, after what, it was 2016 was the date,
Was the date he has to legalize.
legalize by.
legalize, and then he would then let the tenants stay there?
Yes.
Yes.
And
See, there's a glitch here, and it's really confusing. I mean, either this building becomes an IMD and goes into, or it doesn't. So I don't even know why this necessarily has come to us.
Well, I think that, let's look at some of the buildings that have come in that are in the residential zones or in mixed-use zones. The tenants, it's good for the tenants to come in to the loft board. Under the loft board, they get more reassurance about their tenancy during the legalization. They get to participate in the legalization process during the narrative statement process, and they get they have protection against harassment. They have, so they have all of these benefits. Whether it's and they go into rent stabilization at the end. So whether it's a residential zone or a non-residential zone, the tenants would like to go in and come under the loft board because they get these benefits. On the other hand, an owner who has a building that he can convert from manufacturing to residential without requiring the loft board to do that would, of course, rather have more of an opportunity to do it in his own way, in his own time. That's why many of these have settled, I assume, because they, you know.
Let me ask another question. So, but if this building begins to get covered in the loft board, then they're subject to that 343 increase over the course of the legalization. In this case, they're not subject to that 343 rent increase. And in which case, once these units become legalized, the landlord can charge any rent under the sun.
Well, under this stipulation, I think that they came to some agreement as to how the rent would be, what the rent was, the base rent would be, and what the different races would be over time.
I understand, but if the building becomes Class A apartment, I don't understand how the base rent can begin the RGB, the increase at that point, because there's no regulation that says that base rent. The base rent has to do with the IMD buildings. It doesn't have to do with buildings turned into Class A apartments.
Exactly, but what the owner, I only can imagine, was, and the tenant's lawyer, what they were, I think, trying to do was to give the tenants all of the benefits that they could do, that they would get under the loft law, while keeping it out of the loft law.
Yeah, well, I understand that.
Okay, that's what they were doing, and that's what other buildings are, you know, that's what the negotiation would be like. We'll let you, we'll meet with you, we'll bring you into the process of how we're going to do the legalization. We will agree to be rent stabilized. We will agree to no vacancy and luxury decontrol. You know, and so basically they're trying to give all of those rights that the tenants seek to the tenants and still stay out of the lawful jurisdiction, Mr. Fogg.
So while perhaps interesting, is this relevant to the decision that we need to make, which is essentially fairly straightforward, right? They've asked for a removal from coverage from their application. We discussed in 2 meetings that that's not kosher. And now the order before us is, are we remanding it to or sending it back to oath?
That's correct.
Yeah. You know, I forgot to do this, but sometimes I look these buildings up, see what they look like. I'm curious of what this building looks like. Mark, you would want to do that, would you?
I'm doing it right now so that we can take a vote and move on.
Isn't that outside the record?
It probably is.
Yeah.
It is. So why don't we vote on it?
Yeah, why don't we have a vote first?
First, before you
Yeah.
do your curiosity.
All right, is there a motion to accept this case? Mr. Fogan accepts it. Is there a motion to second it? I'm sorry, Ms. Kurtzman, thank you. Ms. Kurtzman seconds it. Ms. Rivera, would you please poll the board members?
Mr. Burris,
Stay.
Ms. Kurtzman,
Yes.
Chairperson,
Accept.
Mr. Delaney,
Yes.
Ms. Bolden Rivera, yeah. Mr. Bobby,
Yes.
Mr. Schachter,
Yes.
Ms. Sheldon,
Yes.
that's 6 yes and 1 abstain.
Six.
Yes.
1, 2, 3, 4, 5, 6, 7 in
I'm
favor.
Sorry,
Seven.
sorry.
We have 3 removal cases. These cases are voted on as a group. They are the Loft Board initiated application, 502 West 44th Street, number LE 0613. Robert Pinkow, 181 Duane Street, number LE 0631. And James Gallagher on behalf of 150 West 26th Street condominium at 146-150 West 26th Street, number LE 0637. Does anyone have any questions or comments about these cases? Yes, Mr. White.
I have questions about number 11, 502 West 44th Street. These units are vacant,
Yes.
but we're setting rents for them
Yes.
because the owner never proffered any, the owner hasn't done any, we initiated this case.
Yes.
Is there,
He did file an application, but it was the fact that he never served. And there was someone in the building, because it's someone he bought out on the ground floor. So, but when we went, there was, the building was completely vacant. But he had to be feeling, there was a filing, or either maybe he didn't pay the fee. There was some filing error, which is why we initiated the case, to bring this, because he got a CFO, and when we went there, it was vacant.
vacant, but did a board staff member inspect the actual
Yes,
units?
yes.
So the 2 units that we're treating as covered units and setting rents for are still have residential fixtures?
Yes.
Yeah, okay.
Right.
But there's no tenant, I mean, this is a bit unusual.
It's right.
Yeah.
It's
So,
unusual.
and there's no tenant to have given guidance to the board as to whether the tenant sought a 1-year or a 2-year lease.
Right.
So
So
we are,
we're not issuing RGB increases, and that's when that percentage is triggered, whether it's a 1%, whether it's a percentage for a 1-year lease or percentage for a 2-year lease. All we're setting is the initial legal regulated rent because we only for RGB increases.
well, we have the somewhat tantalizing sentence at the end of the 3rd paragraph. The period of these rent levels begins upon the first rental after the issuance of this order.
Right, because that is initial legal regulated rent.
So the period, which is, well, if the tenant doesn't answer, it's imputed to be 1 year.
Exactly.
Okay. So that period, presumably, if some tenant showed up and knew what was going on in one of these units, could try to demand a 2-year lease, I guess.
Yes.
Okay, all right.
Just to ask a very basic question. So if let's say that, we approve this, we're done, set the rents for the second and third floor, which are vacant, and then the owner then rents them out, the owner is constrained to rent them at these rates?
Yes.
Okay.
Well, if he's really smart, and he registers with the Rent Stabilization Association, and he rents it at a much higher rent, and the tenant doesn't challenge it within 4 years, that higher rent will become.
Regardless of this.
Yeah. But that's
That's another issue.
outside our.
Can
accept these cases? Ms. Shelton accepts. Is there a motion to second? Mr. Fogan, second. Ms. Rivera, please poll the board members.
Mr. Burris,
Yes.
Ms. Kurtzman. Yes. Chairperson,
Accept.
Mr. Delaney,
Yes.
Ms. Bolden Rivera,
Yes.
Mr. Puckett,
Yes.
Mr. Schechter,
Yes.
Ms. Shelton,
Yes.
8 in favor.
This will conclude our July 17, 2014 Loft Board public meeting. Our next public meeting will be here at Spector Hall, 22 Reed Street, first floor, on September 18, 2014 at 2 p.m. Board members, please sign and hand in your attendance sheet.